Good evening, everyone, and a very warm welcome to this important webinar. Thank you so much for spending the time today to join. And I hope that this is going to be a really useful webinar for you. So just as a brief introduction to the webinar, we will be talking about two important pieces of consultation that are being released currently. And we will be having the opportunity to discuss these in more detail and equip ourselves with understanding what's going on. So as a brief introduction to myself, I am Dr. Nadia Khan. I am part of the British Islamic Medical Association advocacy team. And as I say, I'm very happy to be chairing this webinar. We are joined with an excellent panel today who bring their experience and expertise to the issues at hand when we're considering these consultations, which will have some significant implications for us as healthcare professionals who hold faith values, but also as we care for patients with faith values as well, and the healthcare that is provided and shaped by the professional-patient relationship. So there's a lot to digest through the consultations themselves when we're looking at them, but I hope that in this webinar we'll be able to give you a broad overview and insight into the key issues as they stand to impact us from the perspectives of the various esteemed panel members that we have today with us. So with regards to the structure of the webinar, I'll be setting the scene briefly and sort of looking at the issues as identified by the BIMA advocacy team. And then I will be handing over to our various panel members who will be introduced by myself, and they will be presenting their perspectives from their vantages of experience. I'll invite you to share your views as well through our anonymous Mentimeter poll. So please do log in using your phones and devices and be ready to engage with that because it helps to inform us as a team and also provides a bit of a sense check as to whether we're hitting the mark with the information that we're giving and with what you're thinking as well. And then at the end of the panelists discussing their particular perspectives, we'll have a Q&A session where you will be able to ask your own questions to various panel members regarding the consultations. So please do put on your and thinking hats around the questions that you might have. And then we will curate the questions behind the scenes so that we're able to answer as many as we can through the course of the webinar at the end. So without further ado, if we can move on to the next slide. So just to give you a brief overview. So the two consultations that we have, one particularly being of interest with regards to the GMC medical role of regulation, is going to be very, very crucial for us to consider and engage with in the next few weeks. And particularly pertaining to the issue of fitness to practice, which our panel members will be going into in more detail. As BIMA, we have provided a broad background guide and context to medical regulation in the UK. So if you're not familiar with the processes as they stand currently, or you want to have a bit more information, you can find that resource on our website. Next slide, please. Okay, so one of the key important consultations that we have in front of us at the moment is the consultation which is relating to the GMC regulatory reform. And this is a piece of work that is being carried out by the Department of Health and Social Care and the Scottish Government, who are holding a consultation, which is importantly closing on the 23rd of June, so in a few weeks' time, looking at essentially the scope of GMC practice and overview. And the key points, the regulatory reform is very broad ranging, but the key points that we are noting are that the suggested proposed draft order seeks to expand the remit of the GMC. So we're looking now at the GMC having oversight more clearly defined across not just the medical profession, but also for PAs, AAs, and the broader training systems as well. There are suggested changes to rulemaking, as I mentioned already, fitness to practice, registration and oversight, so very broad ranging, and also the implementation of Lord Mann's review recommendations, which is a review that's been carried out very recently on anti-Semitism and other forms of racism. The full recommendations and report isn't out yet, but will be imminently, so that's to be noted as well. And there is a broader shift with the draft order that the GMC will be taking more of an interventionist approach to regulation. Next slide, please. It's a in-depth reform, and there are a number of different elements to it. But the particular concerns as BIMA we have highlighted through our particular consultation response is that the GMC is looking to retain the right to appeal, which we are concerned about will impact the independence of tribunals that are held. There are expanded interim powers as well, which may open up the inadvertent risk of having early suspension of medical practitioners. There's potentially lower thresholds for intervention as well, and so that will expand potentially the wider scope for referrals. There is an issue of consensual disposal, which relates to the GMC and the doctor in question potentially coming to some form of agreement, which isn't as transparent as the current processes that stand in place. And also there are concerns around freedom of expression having a chilling effect with the reforms that take place. Next slide, please. Alongside this important consultation, there's also the personal beliefs guidance and medical practice guidance consultation that's taking place. So this is where the GMC is looking to update their current guidance on this particular issue, and it's out for consultation, which is closing fairly soon on the 11th of June. This particular consultation is looking at the guidance that really regulates and provides oversight on how we discuss beliefs, how we may have issues of conscious sort of coming into play as well, and how that is expressed through behaviour and expression. And it applies particularly in clinical and professional environments. That's very clear cut with the guidance as it stands. However, there are concerns that it ends up narrowing faith-informed care, and there's a potential blurring of the boundaries in practice between professional and private life as a result of the guidance. Okay, and so just to go into the sort of overall concerns that BIMA has, there is some ambiguity on the notion of imposing beliefs, which is mentioned within the guidance, and the fact that this might have a disproportionate impact for professionals either from a faith background or who are working within faith-based sort of medical care and support care. There are potentially different restrictions that will take place on discussions around faith within the role of healthcare. And so this will have a consequence for holistic and person-centred care. We feel that the conscientious objection is potentially weakened in practice by the proposed change in guidance, which may be of import for issues such as assisted dying, and that there is a risk to faith-informed and culturally competent care. And also we feel that the guidance is open to creating space for workplace bias, and that it's unclear in terms of the boundaries that are in place for expression of faith. Next slide, thank you very much. So that just gives you a brief overall view of where we stand from a BIMA perspective. And I am now going to just introduce you to our first panelist who will be speaking today to provide her perspective. And I'm very, very pleased to introduce Tista Chakravarty-Gannon. Just as a quick introduction to her, Tista has worked for over 25 years supporting survivors of abuse, and she now co-leads the outreach team at the GMC and heads up their work to support doctors who are qualified overseas. Besides that, Tista is also co-vice chair of APNA NHS and has previously worked on collaborative projects with the Gold Standards Framework and Barnardo's, including co-producing the minimum standards on IMG induction with the NHSE, BMA and MPS. And she has provided expert support to the National Guardian's Office, final Speak Up review. So thank you so much, Tista, for joining us, and I will hand over to you.
Thank you so much, Nadia. And it is so good to be back at BIMA. And I'm so sorry to have missed Glasgow. I was saying to a couple of colleagues before, I managed to very dramatically break my arm. So I missed you all. So it's good to be back. And I'm also really grateful to you at BIMA for organising this webinar. Because whilst we often talk about things like, I don't know, past cases, applying GMP, which I'm always very happy to do, this is very different because it's about you influencing the future. And I think the regulatory reform changes in particular, these are genuinely seismic. And it would be an egregious scenario for this kind of change to go ahead without being shaped by those it affects. So I guess that's my pitch to you. Yes, it's important for organisations to respond to it, but I think it's important for individuals to respond to it as well. So I am going to be covering that, but I'm going to start with personal beliefs. So have the next slide, please. Now, there's a QR code to respond to our consultation on personal beliefs. What I will say, the majority in this draft, the majority of the duties that we have, the standards around it, haven't really changed. So, for example, we still encourage colleagues to get that understanding of patients' spiritual needs. It still covers things like balancing, practicing in line with your beliefs and the restrictions that may apply. But just because not a huge amount's changed, in fact, as Nadia has laid out, there are areas that we know people are particularly interested in. So I'm just going to spend a couple of minutes headlining those. So if we could look at the next slide, please. Now, to be clear, to start with, I guess, this piece of guidance is not about the expression of beliefs outside the workplace, but it does cover all these other areas that are salient. So Nadia mentioned the imposing beliefs element, and I'll come to that in a second, but I'll just let you scan those bullets for a moment. So those first three bullets are around that area, and I thought it'd be helpful to clarify what we mean by that. So I'm going to give you a couple of scenarios, and they're not, to be clear, they're not all GMC case scenarios, they're just ones that I'm aware of through my work. One of them is a GMC case scenario. So in one instance, there was a vegan colleague who was encouraging colleagues to cut out meat and dairy, and it did tip over into quite harassy type behaviours. So that kind of thing, imposing beliefs with colleagues. Another one, this was GMC, but there was a colleague who didn't approve of women wearing hijab. And that was obviously absolutely discriminatory. Not only was it Islamophobic, there were a number of sexist tropes there as well. So again, absolute imposition of beliefs. Another scenario was someone who was encouraging colleagues to join a union. Tom, not the BMA, it wasn't a doctor colleague as it happens. And it was quite interesting because instead of just promoting the benefits of value of being in a union, it tipped over into him being quite hostile towards colleagues who wouldn't sign up to this particular union. So there's that. And I suppose when it comes to patients, it's things like your lifestyle is a problem, turn to God, that kind of thing. So that's what we mean by it. However, please do respond to the consultation if it is useful to have those kinds of illustrative examples, supporting information, etc. Another area, the fourth bullet, that is brand new. So there's new support around being subject to discrimination, and that's been universally welcome in early feedback, but you may want us to add more. Finally, a couple of other topics that I wanted to highlight around this consultation. If we move to the next slide, please, Naomi. We've touched on conscientious objection, and Nadia's mentioned that there's some concern it reduces protections. Now, I was chatting with the policy team earlier about this, and we don't really see any substantive changes in what we say around this. The consensus is that it's clearer and quite helpful. So it is really, really important for us to hear your feedback and specific feedback as well on what you think is not helpful. So please do respond with that. We have also got some more detail on, as I say, balancing practicing in line with your personal beliefs and what contractual obligations may restrict. And we reference things like working patterns and policies on dress codes. And we're really interested to hear your feedback on whether we should say more in that draft about, for example, if that environment, if that workplace isn't inclusive. So please do share your thoughts on that. And I'm going to, because I'm covering reg reform there, I'm going to leave it there, but just finally say it is really important for you to respond if these areas matter to you. There can sometimes be a perception that consultations, particularly when there is a draft, don't have an impact. But as some of you will be aware, because of the work that we've collaborated on, paragraphs 47 to 59 of GMP completely changed as a result of feedback from colleagues on the ground. And those are the paragraphs that are most lauded, most welcome, if you will, by everyone. So it does make a difference. And I should also mention, I had a check of demographics in terms of response a couple of weeks ago. And we were looking good for Muslim respondents to the consultation, but we were looking less than ideal for Asian respondents to the consultation. So we've been promoting a lot in that area. So yes, so that's the personal beliefs. Please do respond as individuals as well as organisations. And moving on, I'm now going to share our view of reg reform. Now, sorry, Naomi, would you click back a second? Thank you. Sorry, I've loaded a load of animations in, which is going to be a bit of a pain for you. Right. Case for reg reform. Colleagues are going to be talking about reg reform in a bit more detail, so I just really want to share our view of it and also some of the feedback that we're hearing. And I think the first thing to say is that the current framework is, in our view, absolutely not fit for purpose. It is adversarial, excessively burdensome, archaic. I mean, the landscape in 1983, the Medical Acts from, was wildly, wildly different. So it's not fit for purpose. And we have been lobbying for reg reform. It was referred to as legislative change back in the day for what feels like eons now, honestly. We thought finally it was going to go through in 2013 with the Law Commission's bill. That didn't go through. Then we were promised that there'd be parliamentary time for it. And then Brexit happened. So there was no parliamentary time for anything. Then COVID happened. And then department prioritised PA and AA regulation ahead of wider reg reform. So that was a further delay. So in headline terms, we are delighted that it is finally happening, although there are challenges with some of the detail now that the draft is out for consultation. And I'm just going to share on this next click some of the thoughts from Law Commission and DHSC on the current framework, and I'll let you scan that for a moment. it's not just the GMC that find the current framework, or clearly it's not just as adversarial, reactive, complex, etc. So how are we planning to respond to what we're hearing? Let's have a look at that now. So on the next slide, thanks, Naomi, next click. There are things that we welcome, and they're what you'd expect, the things that we were lobbying for, basically. I'll let you scan that. So this is what we were expecting out of reg reform. There are things that we're highlighting as things that need questioning, further clarification. So if we look at the next click, sorry, the colours changed on the presentation, so that's not super clear. But drawing out one of the examples, for example, the publication and disclosures of warnings are overly restrictive in the draft. There are some warnings that we would not want to publish for that long, but the draft as it stands, super restrictive. And then the next click is the big curveball. And if I weren't sticking to the very sensible 5-slide rule, then I would have had a slide with a massive curveball being thrown, because this, I think, surprised everyone. The Mann review recommendations are such that that DHSC now want us to retain and indeed expand the right of appeal. So this is not something, to be very, very clear, this was a complete surprise to us and not something that we've asked for at all. Okay. We were content with the Williams and indeed our own Commission Hamilton review. So yeah, this is a huge surprise. We've not commented a great deal on this at this juncture because the Mann review is not out. We believe it will be out tomorrow, so we don't know what the full rationale underpinning all of this is at this juncture. So those are our views at this point, but I just finally want to share what we're hearing most often from stakeholders on the ground, because we've been speaking with stakeholders a lot about this. So if we could look at the next click, and sorry, there are about 72,000 clicks now. Well, 4. So as you'd expect, stakeholders do universally welcome that policy aim for a more compassionate process and that greater transparency and accountability. However, and yeah, Naomi, feel free to click the next 2. Yeah, there are a couple of things, such as the language of the draft opens up certain risks. So, for example, it says something around CCTs being available to person such as medical practitioner. It also, the language is such, it opens a risk for the constitution of our board and indeed tribunals that hear cases concerning a doctor to be constituted without a single doctor. Now, we have made it clear that those things are absolutely not our intention, but the language of the DHSC draft, as I say, opens that risk. And then finally, final click, you'll be pleased to know. As I say, that the biggest thing that we're hearing about is, unsurprisingly, the right of appeal. Now, I meet with stakeholders of all interests and talk about all kinds of things, whatever we've been engaging on, even if it's wildly different from regulatory reform, this has been coming up. And the concerns, as you'd expect, are also that it will erode trust in the regulator and indeed, consequently, subsequent public confidence. Now, the idea is that reg reform this will be a template for all professional regulation in healthcare. So it affects everyone. So that's it, really. Just again to reiterate, this is a seismic shift, and it's incredibly important that everyone responds to the departments. And I do want to emphasise that, not the GMC's, the department's consultation. Thank you very much.
Thank you so much, Tista. Thank you for really reinforcing that message that we need all individuals to really respond and add in their voice on the issues. Thank you. We'll move on to Dr. Tom Kane. By way of introduction, Dr. Kane is chair of the BMA's Professional Regulation Committee, which deals with matters pertaining to the GMC and medical regulation. He's a retired consultant in radiology and nuclear medicine based in Lancashire and has, in addition to several years' experience on the PRC, previously been an officer of the BMA's Consultant Committee and Private Practice Committee, and is currently also Deputy Chair of the North West Regional Council and Retired Members Conference. So thank you so much, Dr. Kane, for joining us, and I'll hand over to you.
Thank you. Yes. I'd also like to really thank Tista for giving most of my talk for me in the last couple of slides, which hopefully will try and reinforce some of the things she said. Next slide. That's just the title. Can I have the next slide, please? Yes, as Nadia put into the introduction, I chair the Professional Regulation Committee, which is a structure within the BMA. It includes representatives from across all the branches of practice. It includes people with GMC and tribunal experience, and it's our lead expert committee on the BMA's response to the GMC order consultation. At this point, I should point out that we weren't the lead part for the beliefs consultation, so it's not something I've had a direct input to other than reading through and signing off the final response. So whilst we'll try and answer questions on that later, what I'm not going to talk about is the beliefs consultation at this stage. Next, please. Right. The BMA has a bit of a reputation for basically saying shan't to anything that comes up that is going to disturb things. But what I do want to try and get through is as much as possible in 10 minutes. There's a huge amount in the consultation, and to go through it in the detail that we've had to do for our response would probably take the whole of this hour. So I'll apologise for just picking out some headlines here. But as you may have realised from Tista's talk, there are things where we do agree. Next, please. Firstly, the new system for dealing with cases under fitness to practice, we are broadly supportive of. Replacing the current system where the GMC receives a complaint, assesses whether there is a case to answer, and if they feel there is a case to answer, they assemble evidence, and then it goes across to the MPTS for a tribunal, which is time consuming. It's very adversarial, as has been said before. It also means that the MPTS, rather like the general court system, can risk being clogged up with a huge backlog of cases, some of which are relatively simple and straightforward for them to deal with. The new system will introduce 3 stages where the GMC will have a panel of case examiners, and they will be empowered to work through the complaint, assess how serious it is, what the level of concern is, and also have powers to discuss with the registrant who is being complained about whether they accept the case, and if there is concordance between both the case examiner and the appellant, if you want, the registrant who is under examination, are able to impose sanctions, an agreed sanction system without it going through to the MPTS. And this looks to be a significant improvement on the current system. We're also, as Tista said, we're very pleased to see retention of health as a separate ground for action. We would like to see English language also retained as a separate ground, but that potentially is more difficult. But we were very pleased, as effectively across the board, there was a campaign to keep health. Next, please. Something else that we are happy with is seeing ground structures within the draft order to give the PSA more oversight, and specifically to compel information from a regulator where the PSA has concern, whereas currently it is a relatively limited ability to investigate what our regulator, such as the GMC, has been doing. And finally, next point, we are pleased that it is finally going to introduce some of the changes recommended under the Leng review, specifically the change of name from physician associate to physician assistant, though, as will come up in one of the slides a little later on, our view is still that the physician assistants should have been regulated by a different regulator, and we would prefer to see legislation in the future shift them across to, say, the HCPC rather than the GMC. Next, please. Now, obviously, there's going to be some areas where we disagree. Next. The first, and this is really working through the way they appear in order in the draft order. The first concern we have is the change to the structure of the GMC itself and the replacement of its current council by a unitary board, which would include the chief officers of the GMC and a panel of between 3 and 14 people, of which at least 50% must be non-registrant. And there is no definition of who the registrant side might be. And there is a theoretical construct here where you could have a 7-member council where all the registrants are physician assistants and no medical staff on the council. And our view is that the GMC, whilst people persons in the BMA who would be quite happy to go back to the old elected council, we still feel that the medical profession should have a significant say in how the governance of the GMC is taken forward. And we believe there should be a clear majority of medical practitioners in the new unitary board, and ideally they should be elected rather than appointed. But obviously that is, I suspect, going to be quite a hard ask of the government. Next, please. The registration system that is being produced in, the order will replicate the current system where there is a single register for both medical practitioners and assistants, associates as they are now, which we would prefer to see as completely separate registers, though the draft order does make clear that these would be the register would be segmented, and it would be impossible for somebody to be on both the associate/assistant register and the medical register side of the register. But the structure of the register is also being significantly changed to having a system of enhancements and restrictions, which will replace the specialist register, it will replace the GP register, it will replace the license to practice, it will replace the concept of provisional registration. The language here is something that we're quite concerned about, because everything which is on your register entry suggesting that you are not a completely licensed and currently registered with license to practice medical practitioner will be called a restriction, whether that is that you are in your first year of practice which would be currently provisionally registered, whether you have been sanctioned, whether you are taking a career break and wish to, as now, would relinquish your license to practice. If you retire but wish to remain on the register, currently you relinquish the license to practice, in future you would need to request complete restriction. And we feel the language is unclear and it is potentially discriminatory. The enhancement system, which replaces the specialist register, as Tista's already alluded to, would include, it doesn't replace the CCT, but it replaces the system currently where somebody is cannot apply for a consultant post without being on the specialist register. You would presumably now only be able to apply for a consultant post if you had an appropriate enhancement. And the language around how these enhancements work is appropriate person such as a medical practitioner, rather than specifically saying doctor. Next, please. We also, and this reads into the fact that under the education part of it, the abolition of the PMET order, which means that the system which CCTs are granted is now going to be set out in rules rather than regulation. And Tista's already alluded to the language here where it says persons such as or appropriate person rather than doctor can be granted for CCT. And it also, because of the abolition of the PMET order, says that indeed the definition of a specialty and what the specialty is will be now entirely decided by the Privy Council with no clarity whatsoever as to how that affects replaces the current system of the PMET order. Next, please. And again, something that we've long argued from the BMA is that at one time the standard of proof used by the GMC was the criminal standard. That was relaxed under Janet Smith, under the Smith report following Shipman to the civil standard of proof. We still feel that it should remain that we should be returned to the criminal standard. Again, this is a long-held piece of BMA policy, which may find quite difficult to get some traction with, but it is something we feel that we should have. Next. And Tista's alluded to the appeal structures. The Mann review, which we are now told is going to be published tomorrow, selected recommendations were lifted out of this as justification for the overturn of the Williams review findings, and as Tista mentioned, the Hamilton review as well, which said that the GMC should lose its right of appeal and that the right of appeal should only be held by the PSA. And under Mann, we've yet to see the arguments to why this should change. And not only change, but to have it be extended to appeals against the interim orders that the MPTS can impose. Buried in the order as well, though, is a significant change to the powers the GMC has to review its own processes, with effectively an almost unlimited power to be able to review decisions made under fitness to practice processes at any level in the GMC process up to transfer to the MPTS. And we believe this produces a significant, whilst it allows errors to be picked up more quickly, it would also give a significant risk of double jeopardy, where the GMC may feel that it needs to re-examine decisions that were made and decide that action should be taken rather than shouldn't be taken, having informed the registrant that there has been the case has been closed. Next, please. I'm going to stop there and basically ask you to take note of that web address. On there, you will find links to all the paperwork that's been alluded to already, the draft GMC order, the consultation page, link to how you can submit your response to the consultation, along with our published detailed response to the GMC order, which I think runs to about 10 pages. But that is on that page there, and you can read through that and pick up some of the arguments we have. I'll stop there because I think I've over my 10 minutes, and we can answer questions.
Thank you so much, Tom, for that overview. We'll move on to our legal perspective now on the upcoming consultation. So I have the pleasure of introducing Kashif Mahmood, who is a self-employed consultant solicitor providing legal advice and representation to healthcare professionals in local disciplinary and fitness to practice cases before their regulatory bodies, such as the GMC and the GDC. Kashif has extensive experience of both sides of regulatory proceedings and has worked as a prosecuting lawyer for the GMC in its fitness to practice directorate for several years. And this was followed by 14 years of defending healthcare professionals in regulatory, disciplinary and coronial proceedings as a legal advisor, and then as lead legal advisor at the Medical Protection Society, leading indemnity provider for healthcare professionals around the world. So thank you very much, Kashif, for joining us, and over to you.
Sorry, am I unmuted now? Thank you.
Yes, we can hear you.
Thank you for that introduction, Nadia. Just a couple of points by way of introduction from me. 10 minutes is no way close to being enough for me to cover the key legal implications of the proposed reforms. I will instead provide an overview of some of the key changes to the fitness for practice process, which I believe will have the greatest impact on healthcare professionals. As these changes are likely to be rolled out across all healthcare regulators in time, what I'm about to share is not limited to just the GMC, although throughout this talk I may mention the GMC, but just for people to keep in mind, there may be doctors on here, there may be nurses on here, there may be other healthcare professionals on here. What's being proposed is likely to catch everybody at some point. The next slide, please. We've heard that the main driver for change is to create a streamlined system focused on dealing with serious risks to patient safety and to have faster resolution of cases. The new legislation will allow the automatic removal from the register of any registrant convicted of a serious criminal offence, such as rape or human trafficking. Under current legislation, a full fitness for practice hearing would be required before such an individual could be removed from the register. That's a good thing, I believe most of us would agree. Another change, the grounds on which a registrant's fitness for practice can be found to be impaired will be reduced from 6 to 3. The new grounds being where the registrant is unable to provide care to a sufficient standard, where the registrant has behaved in a way which amounts to misconduct, or where the registrant's fitness for practice is adversely affected by a physical or mental health condition. Why is this significant? Firstly, we can make an educated guess. We won't know what these terms mean, whilst we can make an educated guess, we won't know what these terms mean until they have been defined by the regulator in their guidance. Secondly, even with the regulator's guidance, experience shows that it's likely to take multiple and expensive trips to the courts before we can be clear on what these terms mean in practice. But the most significant feature of the new reforms is the move to earlier resolution of fitness to practice cases by giving the GMC's case examiners more powers of disposal. Can I have the next slide, please? I would like to mention a couple of things before I talk about the case examiner's new powers. Currently, the GMC are not usually allowed to investigate any allegations which relate to matters that took place more than 5 years ago. This 5-year rule is dropped entirely from the new legislation. Put simply, things which a registrant may or may not have done in the distant past could now be brought up to hurt them in the present. At the moment, before the GMC refers the registrant to the case examiners, they must clearly set out all the matters which they believe suggests that the registrant's fitness for practice is impaired. This makes it easier for the registrant to see what exactly is being alleged. In the new legislation, the GMC must provide a statement of reasons. Now, time will tell if this is more or less helpful for the registrant. I'll now move on to what is perhaps the second most controversial change, the new powers for the case examiners. Currently, case examiners are made up of registrants and non-registrants who make certain decisions at certain stages of the fitness for practice process. The new legislation no longer requires the case examiners to include registrants, which in itself could reduce confidence in the fairness of their decision making. At the same time, the case examiners will be given new and far-reaching powers that include being able to impose, without a hearing, any of the full range of registration measures. The term registration measures is used in the legislation as a replacement for what we know as sanctions. Essentially, it means the same thing, but a new title. What is more, the case examiners could impose a sanction without the registrant's consent where the registrant does not reply within a set time. It doesn't stop there. The case examiners would also have a power to review and modify both final sanctions and interim measures, all without a hearing. The argument for giving the case examiners such extensive powers is that this could avoid a need for unnecessary and costly hearings where the registrant is potentially happy to accept a particular outcome. However, the concerns that I and other defence lawyers have about this is that registrants may not fully appreciate the consequences of accepting a particular outcome and might do so to save on time, cost, and the stress associated with fitness to practice proceedings. And even if the registrant accepted an outcome, that may still not be the end that they were hoping for. I'll talk about this a little later. Next slide, please. Clearly, some thought has been given at addressing these risks to healthcare professionals. A registrant could, for instance, invite the registrar to review almost any of the decisions that were taken by the case examiners. Failing that, the registrant could ask for permission to challenge a case examiner's decision at an internal appeal panel hearing. If that were unsuccessful, the registrant could bring an appeal to the courts. Of course, none of these routes guarantees a successful outcome for the registrant, with each getting progressively more expensive. Unfortunately, it doesn't end there. Could I have the next slide, please? As you can hopefully see from the slide, others, including members of the public, could also ask the registrar to review a decision where they felt the decision did not go far enough. The Professional Standards Authority, which is the statutory body that oversees healthcare regulators on behalf of the public, will also be given more powers to obtain information from the GMC, which, as you may have heard from Tom, is not necessarily a bad thing. The PSA will also be given more powers to challenge and appeal more decisions of the GMC and the fitness to practice panels than it currently has at the moment. So yet another route, another opportunity for cases to be dragged out for longer than they need to be. However, it does unfortunately get worse still. Next slide, please. Despite everything we were told since 2018 by successive governments and the GMC get to hold on to their right to appeal fitness to practice panel decisions. If that wasn't enough, the GMC will acquire a right to appeal fitness to practice panel decisions on interim measures where an order is not made or where the GMC feels the order does not go far enough. Next slide, please. I've only been able to scrape the surface. I can't emphasize enough how significant these proposed reforms will be for all healthcare professionals. I can imagine that many of you will feel very let down by these changes. I know that the next speaker will have more to say on this, but in terms of some practical takeaways, I would like to offer you the following. These changes make it more important than ever for a healthcare professional who is faced with a fitness to practice concern to obtain expert legal advice at the earliest opportunity. We all know, sadly, that healthcare professionals from ethnic minorities are more likely to be referred and more severely sanctioned by their regulator. I fear that this problem will be made worse by these changes. With this in mind, please make your voices heard, which you can do in a number of ways. Firstly, by responding individually to this consultation from the government. Secondly, by sharing your views with your indemnity providers. And thirdly, by continuing to engage with organizations like the BMA, but also like BIMA. A collective voice on a consultation like this is likely to carry far more weight than our voices alone. Final slide, please. I'll leave you with my contact information should anyone like to pick up this or indeed any other issues with me separately. And I'd just like to thank you all for your time and to BIMA for allowing me the opportunity to present to you today. Thank you.
Thank you so much, Kash. Really sobering reflections there for us. I'm now going to move on to our final panelist, Dr. Shazad Amin, who will give us a sense of the sharp end of the issue, really, when it comes to freedom of political expression and the challenges that lie ahead potentially with the reforms that are proposed. Just by way of introduction, Dr. Shazad Amin is a consultant in adult psychiatry. He has an interest in professional regulation and is part of the BIMA support group for professionals. He is currently a Nursing and Midwifery Council Fitness to Practice panel member and also clinical advisor to the General Pharmaceutical Council. He's formerly sat on the Medical Practitioners Tribunal Service as a chair and member from 2012 to 2024. So I'll hand over to you, Dr. Shazad, with your slides. Thank you so much.
Thank you. Can I share my slides?
Yes, you should be able to.
Where's the thing? Sorry. I can't see the share slides option.
If you go to more, if you've got more at the bottom in the toolbar, start share.
Could be on the bottom.
Yeah, got it. Yeah, I've got it. Yeah, lovely. Okay, if you can see that, and I can just do the slideshow now. Right, thank you very much for that introduction. Can you see this? Can you see the screen?
It's a white screen at the moment.
The white screen up here.
Oh,
okay.
Yeah, there we go.
Okay, that's fine. Yeah, that's make it work away. So yes, so I'm going to be talking a little bit about a topic hasn't really been discussed yet. I think Tista and Kashif mentioned it, and Tom as well, the MAN review, which is coming out tomorrow. So it's important for doctors and indeed everyone who want to look at these proposals to understand that with regards to, and I'm going to focus on the right to suspend doctors under investigation, the right to appeal MPTS decisions. Those two areas particularly, I think, are of interest, certainly to BIMA members. For those particular areas, to understand there's a political context to this, yeah? And unless you understand the political context, you can't fully appreciate why these proposals are being made now. Now, I appreciate, as I said, these have been long in the gestation, but there have been some recent developments which people really need to understand, yeah? And that's what I want to focus on.
Dr. Shazad, sorry, just to mention, we can just see a white screen at the moment. I don't know if that's
that's fine. Yeah. So the recent story, the recent political context, I will take back to 2025. Now, even going back further than that, the context I want to talk about is the war in Gaza, yeah, which of course that conflict Israel-Palestine has been going for 50 years, 60 years rather, and recently, of course, the attacks in 2023. Have actually changed a lot of the political discourse, certainly in this country and other countries as well. And I want to pick up the story with an MPTS interim tribunals case in 2025 of a doctor called Dr. Rahma Al-Ladwan, who was actually accused of anti-Semitism, making comments that were anti-Semitic. And she was referred to the MPTS interim orders panel, and they looked at her comments. Now, an interim orders panel only considers one issue alone. It considers whether the doctor should be suspended immediately pending an investigation. Yeah, it doesn't decide whether the doctor was guilty or innocent and the rest of it. Yeah, so they decided not to suspend her. This caused a public outcry, and one person who was particularly upset at that was Wes Streeting, the former Secretary of State for Health. And he actually, rather than make his views private, he went public and said on public social media, I have no confidence in the ability of our medical regulation system to keep patients safe, and I'm taking urgent advice on next steps. So that's an amazing statement. In my whole 12 years in the MPTS, I never heard a minister actually speak out like this on, a hearing outcome. Basically, yeah, unprecedented. Yes, now he's not just any politician, not just any MP. He's a Secretary of State of Health, publicly calling out the MPTS as basically unfit for practice. Yeah, essentially. So, following that, the solicitor Dr. Adwadwan, not surprisingly, made this comment that he was basically out of order, really, yeah, and he was undermining the independence of the judicial process, which actually it is. The MPTS is part of a quasi-judicial process. Following that, basically he ordered a review from John Mann, who was a government independent advisor on anti-Semitism. He made some recommendations. They didn't publish them. We're hearing them be published tomorrow. But in any case, he obviously has seen them, and they incorporated the Mann recommendations, basically stating in broad terms that anti-Semitism was a major problem in the NHS and needed to be sorted out in various ways. They incorporated them into the draft order. Yeah. Now that's something also extremely important. I'm sorry, I should add basically. Sorry, 1 minute. Tech isn't working. Yeah. Again, this is a quote from the government consultation, basically stating that they actually incorporated his rapid review, as it were. And you can see the phraseology into anti-Semitism and other forms of racism. Well, I think the second part of that is being disingenuous. This is focused on anti-Semitism. It wasn't focused on racism more widely. It wasn't focused on transphobia, homophobia, or any other particular discriminatory practice. It's focused essentially on anti-Semitism, and that alone was driving these changes. Now, when we talk about anti-Semitism, we can't ignore the wider context. And the wider context, certainly since 2023, has obviously been the war in Gaza. And whether you are which side of the debate you're on, there is no question that this has significantly influenced public perceptions and actually, caused people to express quite strong political views. Now, one of the contexts the government is very, very aware of is that it has been accused of complicity in genocide by a number of organizations. Yeah, I know we haven't got time to go into all the reasons for that, but certainly weapon sales to Israel, sharing of intelligence and various other things. Alongside that, the public and doctors as well have seen evidence of actual basically Israel's being accused of a genocide, basically things like destroying the Palestinian healthcare system. We've had doctors being abducted, a number of human rights organizations talking and reporting that they've been tortured in custody. We've had double tap attacks on ambulances, rescuing people in distress. So a number of areas. So a lot of human rights organizations have actually commented on this. But the government has singly refused to cause it a genocide because obviously if it did, he would be complicit and there'd be legal ramifications of this. Now, within this process, one of the important things to look at, and one of the things that GMC and certainly the MPTS looks at, is public opinion. Because it asks the question, what would the ordinary member of the public think about what this doctor has done or said? And one of the ways we can look at that is look at opinion poll data. Now, YouGov has been actually polling the issue of Israel-Palestine conflict for many, many years. They've done surveys every 6 months between 1,500, 2,000 members of the public, weighted and stratified, and asked them simple question, do you sympathize more with the Israeli viewpoint or the Palestinian viewpoint? I'm not sure whether you can see this back at home. I'll just show you. It's a simple graph with a timeline at the bottom. The last survey was taken only 2 days ago. But if we go back and to November 2019, we see that the percentages, relatively speaking, of people sympathizing with Israel was about 12%. Those sympathizing with the Palestinian cause was about 22%, something like that. If we go fast forward to today and see that change over the past couple of years particularly, we end up with people supporting Palestine at 32% and people supporting Israel at 16%. So twice as many people in the public would support the Palestinian viewpoint rather than the Israeli viewpoint. Now, of course, that is a problem for the government because obviously that is reflected in people's political views and people's voting habits. And you'll have seen the recent local elections when there was a number of candidates were standing on pro-Palestine tickets. And in fact, this stat here, more of them got elected than the Labour candidates. And of course, you'll also remember that at the general election 2024, 5 MPs were elected on a pro-Palestinian ticket, which has never happened before in the history of parliamentary elections in this country. So the government seriously is quite concerned about public opinion and how that is now reflecting into people's political choices, especially with the rise of reform. And we haven't got time to discuss the deeper politics of that, but that is very, very relevant. And you might ask the question, well, that's fine, but why is the government so interested in doctors' view? Because obviously doctors as a community, we have a duty to speak out when we see injustice. And certainly some people would see that as a core feature of a doctor's job, is to speak out when they see injustice. Yeah. And here's an interesting graph. And again, this is something done by Ipsos Mori. They do something called the Veracity Index every year. So what they do is they take groups of professionals and ask the member of the public for each type of person, i.e. each profession, tell me if you generally trust them to tell the truth or not. Yeah, fascinating question. And I've been using this slide for years, basically, in my presentations. And you'll see, I'm not sure whether you can, that at the top of that, nurses are the top of the list, basically. Yeah? But doctors are number 3, 85%, basically, yes, say that we trust doctors to tell the truth. Now, if you contrast that with politicians and government ministers, at the bottom there, 9% would trust politicians to tell the truth, and 14% government ministers. Now, you can draw your own conclusions from that, yeah? But I would suggest this is kind of data done by an independent polling organization, which suggests actually doctors have an important job, an important role in actually, you know, raising issues like this, and the public would give them greater weight than they would give to government ministers and politicians. You might not be surprised by that, but that is what the data states. Now, when we look at this particular issue, coming back to the GMC, I think a lot of doctors that I've certainly counseled, a lot of my colleagues have counseled on the BIMA support group, are extremely concerned about the way the GMC conducts its investigations in terms of fairness and due process. And I'm going to give you one current example, and everything I say is in the public domain, so there's nothing kind of, there's no inside information or anything like that. One example which illustrates some of the issues that doctors are concerned about. So this is a hearing, sorry, this is a case which was originally referred by UKLFI, UK Lawyers for Israel, which is on its website says basically it's an organization which is generally pro-Israeli, yeah? And that referred this doctor called Dr. Ghassan Abu Sitta, who is a Palestinian surgeon who has worked in Palestine and basically operated on Gazans and children and actually has seen firsthand some of the horrific injuries the Palestinians have been subjected to. Now, he basically was referred for a fitness to practice hearing to the GMC, which essentially referred the matter to the MPTS, Medical Practice Tribunal Service, and their fitness to practice hearing was held in January of this year. And that's determination is on the public record. You can go and read it for yourself. I would encourage you to do that. It's available there. The whole hearing, the whole transcript is there for you to see. Now, I'm going to summarize it for you, obviously limited time. But essentially, these were the allegations that Dr. Abu Sitta wrote an article in Arabic in a Lebanese newspaper in 2018. So we talked about the 5-year rule. I'm not sure how, but and there was a discussion about that. But anyway, the tribunal allowed it. But 2018, i.e. 8 years ago, an article written in Arabic whilst he was living there, and he wasn't even registered with the GMC at the time. But anyway, that was one of the allegations. And the allegation was that that was supportive of violence and terrorism and anti-Semitic. There were also some comments on Twitter, X, now the date wasn't given, strangely, regarding the organization Hamas and that they were supportive of violence and terrorism. Now, the MPTS looked at all this very, very carefully, came to a very considered judgment and concluded that the facts relevant to impairment were not proved. Yeah, essentially, it threw out the case, saying basically Dr. Ghassan obviously admitted he wrote those comments and wrote the article, but basically there was no case to be made on impairment, therefore the case didn't proceed. Now, the GMC leadership, this is Charlie Massey, who's the chief executive, Anthony Olmos, the director of fitness to practice, and others, met on the 12th of February. Again, this is a public document, you can check it for yourself. And they looked at this case and they concluded the MPTS determination, finding that none of the facts proven was not sufficient, i.e. basically the MPTS got it wrong, and the facts basically they were not sufficient to protect the public. And they've appealed this case to the High Court. Now, you can form your own view as to whether this should have been the correct process or not. Don't forget, the GMC had basically agreed following the Williams review that it would not appeal cases, basically. Yeah? So that, for some people, is a breach of trust, and regardless of the merits of this particular case. Now, since then, there has been an outcry. There's been a campaign. There's an organization called Healthcare Workers Against Censorship, which has been set up, which on their website say they have collated 2,000 signatories of doctors calling for the GMC leadership, who decided this essentially, to resign. So it's not a minor issue. And obviously there's a crowdfunding appeal for Dr. Sitter's case, and it has garnered a lot of attention, certainly within the Muslim community and wider as well. And they produced a video in which Dr. Abu Sitter has commented on this. Again, this is all publicly available. And his basically comment was the aim is to create a McCarthyite culture of fear. So the doctors do not speak up. And he's been very outspoken, by the way, on some of the things that he has seen. We haven't got time to go into those. So he is quite clear that this is not really a fair referral, that there's essentially a type of witch hunt against him and other doctors who have spoken up for Palestinian rights, etc. really. So that I will leave you there. I encourage you to look at that, because that does raise a lot of the concerns that I am hearing and other colleagues are hearing as well. Now, the reason I was asked to speak was actually to give some views and guidance onto how clinicians should react to the draft order. And again, I'm going to focus on the areas that I'm just in the areas I'm talking about, not the wider reforms really. And what I will say on that, oh, sorry, this has all come together. I'll just read them individually. So first of all, the GMC should not have the right to suspend doctors under investigation. Now, at the moment, only the MPTS interim orders panel, that's a 3-person tribunal, tribunal rather, can suspend doctors. So if the allegations are serious and the GMC deems that it's important for public safety or professional standards to suspend that doctor immediately, and for example, there may be a sexual abuse case where there's a real risk to patient safety, the MPTS interim orders tribunal will look at that particular case and decide whether to suspend the doctor or not. Now, partly because of the cases we've heard about just now, there's a possibility the GMC, while the doctors are under investigation, could suspend doctors while they're being investigated. Now, that for me would be extremely concerning for 2 reasons. One is the GMC should not be judge, jury and executioner, essentially. Yes? Whilst it's investigating a doctor and bringing allegations against the doctor, at the same time, it surely cannot, with due process and fairness, decide to suspend the doctor or not, i.e. it's not independent, because it's bringing the allegations. Well, all it's deciding here whether it's serious enough to suspend. And secondly, we know from various anecdotal cases and looking at, the correspondence, that the GMC is under pressure from a number of organizations, actually, in all sorts of ways, and therefore it has that pressure to worry about. Now, if you contrast that with the MPTS tribunals, they don't have to worry about pressure from external organizations. They are completely independent. They don't really care whether the doctor is guilty or not of the things that have been alleged to have done. They're simply focused independently on whether the doctor at this point in time should be suspended. And I think, having looked at worked in this particular area, that is a very fair process. And actually the MPTS function in this respect should not be undermined and should be respected. Secondly, we've already heard about the right of appeal. I won't repeat the Williams review. The GMC agreed that it basically would lose the right of appeal. And this all stemmed, if you recall, from the Bawa Garba case, which caused a furore in the medical community. And now for the GMC now to basically be back on the agenda, again, we seem to be going backwards. We seem to have forgotten all of the lessons that we purportedly the GMC learnt in the Bawa Garba case, as it were, and we're just turning the clock back, really. Yes, and at the end of the day, either the MPTS as an independent tribunal is respected or not, really, and I think that is the crux of the matter. That basically undermining the MPTS. So basically, the GMC can refer to the MPTS. If it doesn't like the decision, it can just refer to the High Court anyway. It doesn't really matter whether it loses there or not. So that's really important, that the GMC should not retain the right of appeal, as has been agreed by the GMC and Parliament, and indeed all the Royal Colleges as well at the time signed a letter stating we do not want the GMC to have the right of appeal. Coming to the narrow issue of anti-Semitism, I mean, there's no doubt anti-Semitism is abhorrent. However, it is not the same as criticizing the state of Israel. And there have been many cases, and I know these are very difficult cases, but the GMC needs to ensure the 2 things are not conflated. Yeah. And in fact, in the case I've just mentioned, Dr. Abu Sitter, the tribunal was very careful to distinguish between anti-Semitism, and they defined it, and basically criticism of Israel or a criticism of Zionism. Yeah, and these things are often conflated, and they should not be. And it's very, very important that GMC needs to do that. As a wider point, people have argued, what is the GMC doing in this space in the first place? The GMC should not be policing the political opinions of doctors. Now, whether they're about Israel, whether they're about sister dying, whether they're about basically abortion, anything that has a political connotation to it, the GMC should not be in this space. And instead, it should be doing the opposite. It should be promoting freedom of expression under Article 10 of the Human Rights Act, which says, and I quote, everyone has the right to freedom of expression, and this right shall include freedom to hold opinions and to receive and impart information and ideas, and the bit in red is the important bit, without interference by public authority. And the government and the GMC by extension is the quote-unquote public authority here. And I think a lot of people are concerned that actually it is getting into areas which it wasn't set up to get into. The UK medical regulator should be politically neutral, shouldn't be involved actually in getting involved in deciding whether a doctor has basically breached good medical practice simply on their political. Obviously, if there are views, there are hate crimes against a minority, or there's a clear breach of that, that's different. But actually, political views is actually something that really shouldn't, the GMC should not be involved in. So I think I'll stop there and I'll hand back to the chair. Thank you.
Thank you so much, Dr. Shahzad, for that insight and for really laying out the impact and consequences potentially that we'll be facing. Really appreciate the panelists' time. I'm conscious we have overrun by 15 minutes nearly, so apologies for those who have had plans otherwise, but I hope that it's been a really useful webinar for you to engage with. We've had some excellent questions come through on the Q&A panel. Many thanks to the panelists who've been responding to some of those, but we are collating those questions, and we will be aiming to get a written response maybe to some of those questions and send them out as a follow-up for this webinar. So I won't go into an open question and answer panel just now, just because of time constraints. But just as a reminder, as we close out, please do engage with the responses to the consultation, to both consultations, and we are on a short deadline for those responses as well, so please do bear that in mind. BIMA will be following up this webinar with sending out some further information, including the Mentimeter, so that we can continue to gauge your views on the issues, and that will help, as I say, for us to tailor our response back. Aside from that, just a reminder about BIMA in terms of our voice being powerful as a collective, and please do consider joining BIMA if you're not already a member, and supporting the work that we're carrying out. So many thanks for your time. A big thank you to the panelists for joining us and providing their insights, experience and expertise, and hopefully we will see you soon again on another webinar in the near future. Until then, thank you very much. Have a good evening, and Assalamu alaikum.